Ozgur, and she's the legal counsel of ASML Netherlands. Give her a round of applause, everybody. And Maysa from Malgueiro, Campos and Zardo in Brazil. Everybody. Please join me in extending a warm welcome to our panellists. Over to you.
Working.
Yes,
right?
it is.
Okay, very good. Okay. Good afternoon, everyone. Thank you so much for joining. We are waiting for more people. I think it's because of lunch we will get a little bit slow. But as we start, I hope that more will join us. Our panel today is about one of the fast-moving and the most complex area in intellectual property, and that's AI-generated works and digital assets. So now we are going to look at the questions that makes lawyers, practitioners, innovators, creators, and also businesses awake at night. I'm Saideh Ahmadloo, and I am Global Lead Counsel in FMCG sector with focusing on innovation and technology. So before diving in to our conversation, I would like to just briefly introducing yourself, and then we will go to the conversation. Ilse.
Thank you. I'm Ilse. I'm legal counsel at ASML. For those of you who are not familiar, it's a semicon tech company in the Eindhoven area in the Netherlands, which is basically a system integrator. My focus is on intellectual property rights. Yeah. Cool. That's me.
I'm Maysa, Zardo from Brazil. I work in a law firm, a partner of a law firm in Brazil. My principal practice is intellectual property and data protection. So I've started working with intellectual property and Natura Cosmetics, a famous company, cosmetics company in Brazil. And at that time we faced the important change for streaming, and now we are facing the artificial intelligence. So I hope to bring you some important insights from Brazil. Thank you.
Perfect. Thank you so much for the introduction. So let's look at the very first question and the most important one. What was the biggest AI IP related risk that we have seen in the last 12 months? If I look at the US, we saw that two main areas are standing out. One is about authorship and copyrightability, that we saw that the Federal Court of Appeal in Washington were looking at saying only the human contribution on AI-generated assets can be copyrightable. So it means that if there is an output fully generated by AI tool, it cannot be copyrighted. And on the other side, also we saw many cases in New York that they are testing to see that for the AI tools that they use trained material, copyrighted ones for the AI tools, they can rely on the fair use doctrine or not. So these cases are very new, and they are opening new doors to look at the copyright and also these AI generated works. What do you think, Ilse, about Europe, and what are the biggest risks that you saw in the last 12 months?
Yeah, so I think also for Europe, I can distinguish the two, let's say, cases. One is the generative AI, so much more related to the output, so indeed related to either patentability or inventorship or copyright protection for any work that is generated with the help of an AI tool. Which I think is an important one, but I think the other important topic is also the use of AI tools. So at least from an in-house perspective, using AI tools for productivity or even for generating inventions could be in the art space or in the technical area, needs certain compliance aspects and risk mitigation to make sure that everyone uses the tool correctly. So I would say that these two topics are for sure the important ones.
Ilse, you mentioned something very important because I was remember Samsung case. Do you remember Samsung case where they used a tool to check if the algorithm they have created was okay to be used? So what happened is we don't need to train only the tool, but also people who work for your company in this sense, to let them know that confidential information, intellectual property not registered yet, for example, in a patent you cannot put information about a patent inside an AI to train the AI, because the AI will absorb that content and maybe can regurgitate this content at the same time. So I remember this important case. So it's something that we are facing, an intellectual property risk, confidentiality, and intellectual property not yet protected, registered, for example, patents, trademarks, and softwares. And also something that I was thinking about right now, I have a client in Brazil that is always asking us for agreements. And as soon as they request us an agreements, they say, oh, is it already executed? Is it already signed? And then I said, oh, I will create a picture for you, a meme in Brazil, we say. I don't know if it's meme, also the same word. But I asked ChatGPT, could you please, who here have already watched Shrek, the film?
Yeah.
Do you remember the donkey? When the donkey says, I guess, Shrek 2, he's asking, oh, are we there yet? Are we there yet? Remember this scene? Okay. So I asked ChatGPT to create the same. Oh, could you please create the donkey from Shrek using the sentence, are these agreements signed, executed yet? The ChatGPT answered, oh, I'm so sorry. I cannot create replicate the donkey because it's an intellectual property. So my terms and conditions do not accept the replications. But I can create a donkey for you, a funny donkey for you to use for this purpose. So it's also IP risk, reproducing intellectual property by these tools. Depends on the terms and conditions. Are these artificial intelligence taking care of third-party intellectual properties? So it's something that's confidentiality information, training people to use it, and also copyright especially.
Yes. So I see that in different regions, the AI risk is taking slightly different shapes, but actually the nature and inherent risks are somehow similar from Brazil to Europe to US. And then it's an interesting question to think that, so if there is an output out of AI tool, can it be protected and how? So we see, for example, in US, the US Copyright Office is looking at the human fingerprint. So they are saying that if there is this output out of the AI tool, and then if there is a meaningful human contribution to it, that part can be protected and that part can be copyrighted, but the rest is not there. And then there will be a question that how we can persuade courts or the registration or the agency saying that, okay, this part is meaningful. And then there will be the question of how we can record this human contribution there. And we can discuss about this more. But how we see, for example, from your perspective about how we can protect this output, because we say this is the output, it cannot be protected, but it doesn't mean that it's totally non-protectable as well.
Yeah, so I think also in Europe, I think more in general, everyone is looking a little bit at each other, right? Everyone is afraid to, let's say, to be the first one, or at least to take a strong position. So I think in general also the human fingerprint, so the intellectual contribution of the human is very critical in Europe in terms of claiming any IP rights. So I would say part of the challenge is to educate or train people to make sure that this is actually an important aspect for at least the company to also claim ownership and to get the protection that it needs, so that we are not, let's say, blocked by formalities. And another aspect is make sure that there is correct documentation. So how can we make sure that we somehow track, for example, the interaction with the AI tool, that we can show somehow that yes, there was an AI tool that helped in the invention, but there is a substantial intellectual contribution. While I also have to note that, for companies that work globally, we have to take into consideration also the fact that, for example, in Europe we don't have this broad discovery aspect for court cases. So it could also be, I would say it's a very delicate balance to make sure that you document, but maybe also not over-document, right? Because you don't know if someone would challenge your IP, what kind of evidences you have created. So you have to, for me, it's really a balance between making people aware of what is important to get the IP protection that you need.
What I think that was really interesting is when we are looking at the output of AI, it can be protectable or not. I saw that some scholars take one step back and they looked at the creativity intent. And they say that if you are just going to the AI model, an AI tool, and just saying that this is a prompt, generate this for me, a picture, it's not considered as creativity. And the whole intellectual property law was created at the beginning to protect creativity of human. And this is the only nature of human, because we have emotions, we have this urge to create things. So when we look at AI, always we have to look at, this is a tool, this is a technology, but creativity should come from human, and only this part needs to be protected to also encourage human to create more, right? So that part I really like to look a little bit back and record what is the intent, and after that the collaboration with AI to produce something as an output. But Maysa, what do you think? What are the things that you think for the protection it's needed when the output is totally generated by AI with some level of human contribution?
It's a good question. For us that work with intellectual property, it's easier to understand that a human must participate in this creativity environment. Imagine explaining it to the judge. That even in Brazil, for example, they even know what a patent is, what a trademark is, what a software is. Imagine explaining to the judge in Brazil that a human must participate in the creativity work in order to have the right to be the owner of that result. So in Brazil, our laws, corporate law, intellectual industrial property law says that a human must participate in the creation in order to be the owner of that result. But the laws are from 1996, corporate law and industrial law. So 1996. Of course, at that time we already have some artificial intelligence, but not as we have nowadays, that we can put ask ChatGPT or any other artificial intelligence and receive the result, receive a copyright already trained. So it's a challenge to know how to protect the results, if there is a new result, I don't know, but something that comes from this regurgitating, but the result of the prompt you have input in the asking him to help you. So, in my opinion, my perspective, and also according to Brazilian law, a human must participate, and the courts are challenging how is the weight needed to provide the ownership of the authorship of the ownership of the result. Is it from the company because you are using a tool provided by your employee? Or are you using a ChatGPT, a free version? How is the terms and conditions of these tools? The agreement between the provider and the user? So all of the things must be analyzed by the courts, and in order to let us know who is the authorship, whose authorship, whose ownership is correct. So it's something that we need to join many documents, many, as Ilse said, documents and expertise and laws in order to have the correct answer for this question.
I remember that. So lots of jurisdictions, they are looking at AI as some kind of a tool, not a creator by itself. There was one very interesting example. They compared AI tool with the first time that camera introduced and invented, right? So they put the camera in jungle between lots of monkeys. And one of the monkeys put a click on the shutter and they took the picture, right? So that picture, that was the picture of monkeys sitting together, by accident, can it be protected under copyright or any kind of copyrights? And the answer is no, because it's not coming from human creativity, and that was the main definition of the authorship that we are now talking about. But if you want to advise a client saying that, okay, you're using an AI tool, and these are the things generated by AI with contribution of human, what kind of documents, how they can record practically these kind of outputs to in future, when the jurisdiction is vague, we do not have lots of case laws, the precedents are very narrow, how they can really record things so in future they can prove the authorship and make the things that they have protected under copyright.
So I think it depends a little bit on the type of work you are doing. So one, I think, very nice example is a copyright case from a Nigerian artist, Malik. They call it was the Elderly series. It was basically a fashion show which was only digital, of elderly people in completely digital outfits. And in his work, you could see that he was really collaborating with the AI tool. So he had basically collected hundreds of iterations between him, the AI tool, and Photoshop. So it was really clear that every time he got output from the AI tool, he would make modifications in Photoshop, give his own tastes and style choices, and then give it back to the tool. So in I would say artworks, there could be a very clear and concise way to showcase evidences that, for example, there are hundreds of iterations, so there is really the intent from the artist, but also the intellectual contribution of the artist. While if you compare that, for example, with coding, software coding, it could be a completely different scope, right? It might also be a conversation with an AI tool, but for example, it would be more relevant that you save prompts or log certain discussions with the AI to show, okay, I'm guiding this tool towards a certain outcome, but my initial prompt and queries were really guiding, let's say, the invention or the outcome. So I think that's really relevant to keep in mind the different contexts.
Very meaningful, because now in US there's a saying that the logs are the new chain of ownership. So recording the logs are so important, and how you look at it, it's also interesting. Because as you mentioned, content to content can be different, and the very interesting example that I can share is when a user using an AI tool to generate 50 pictures. So this is not copyrightable, because this is totally the output of the AI tool. But then, marketing person, look at these 50 pictures, select some. This selection, this act of selection is copyrightable, and that's very interesting. And then, putting something on top, putting a message, change the pictures, putting a message on top of that, and creating a marketing campaign, all of these can be protectable, but if it's recorded in a good way, showing that this selection happened on top of these, and after that, this can be useful. Maysa, what do you think?
And I agree with you. Logs registration is the most important things to go ahead. And especially because the courts, as I mentioned, don't know how to proceed. They need tangible proof in order to make their decision. I wasn't about to bring this, but I read this in the morning, and you were talking about, I remembered, a case, I didn't read the complete sentence of this case, but a theme park in Santa Catarina, in south of Brazil, I don't know if you have ever been to Brazil, tried to use songs created by AI. to avoid paying fees to Eijk, because in Brazil, when you make it public, when you use music in public, you should pay a tax to Eijk. Why they did that using a song created by AI? Not to pay this fee. So if there is no human author, there is nothing to pay. But in preliminary decision, the Court of Justice of Santa Catarina upheld the fee. AI doesn't create from scratch. It is fed by pre-existing works, mixing excerpts of melodies, lyrics, and arrangements that belong to the real authors. So, what's the proof? The song São Paulo, by the virtual singer Tocana, I don't know if it's the correct pronunciation, was taken down from platforms after a request by Jay-Z, because it used reference for Empire State of Mind without authorization. What does it mean? Does it mean, in my perspective, that it depends on the case, as Ilse mentioned. Music using part of songs to create a new song, so they had feasible, tangible proof that the song was created using previous intellectual property.
Yeah, music can be really complicated, but that's a very good example. We talked about protectability and copyrightability, but now let's, with your example, take one step back on training part. When the AI models are using lots of copyrighted materials to get trained, can we say this is the infringement of copyright or not? We see that in US, as I just mentioned, in New York, lots of big players, they are testing to see that is it a fair use or not. And you know that fair use doctrine has 4 elements, but the most important question is, these AI models got trained, and this training can be transformative or not. Because if they can prove it is transformative, they can really build the basis of fair use, and that means, yes, it's fair use and you can use it. On transformative, the defenders are saying, look, these are really transformed because the AI tool changed them to numbers and patterns, and they are just getting patterns. They are not taking the text, all the text become alphabet to numbers, and after that very complicated mathematicians on the back working in a way that it's transformative and even highly transformative. So they are building the basis that this training can be transformative. On the other side, the plaintiffs are saying no, because we can see that the exact text of a novel or a paper is there, so it's all highly similar, so it's not transformative. So the challenge is there, but in my point of view, which we are going to talk about memorization of AI tools as well, but this is the interesting part, that yes, it is transformative, but in a very new way. It changed, so the original documents and things are not there, and then there will be a question that, so why the outcome is very similar to the original work, and how we can see it is different. I saw an idea that someone were talking about, that nowadays, if you look at the output of AI tools, if you work with AI tools, I'm sure you know, you can understand this text or this document is created by AI, right? You go to your LinkedIn, you know this is AI because of the method of writing, the nature, the tone, you can say yes. Also, they say it is similar to lots of other things. So the defenders are using this argument, saying that the output is not similar to human output, it is transformative, and there is no substantiality, similar, basis with the original work. But how Europe is looking at this idea, on how they see the training, because I know that EU AI Act looking at lots of transparency requirements, how they see the training of AI tools.
So indeed, in Europe, we don't have the fair use doctrine, but if you look at the AI Act, then we see obligations like transparency, which is a very broad open term, so it's basically also connected to, let's say, the risk level the AI system is or should be classified. So I think that makes it, let's say, more open to interpretation. And also an open field in that sense. So in terms of risk mitigation, it's less clear what the criteria will be, depending on the AI tool and the specific case that we would discuss. So I think in that sense, it's a lot of things are still to be seen, and I think indeed what you mentioned, the fact that there is a technical transformation doesn't imply that from our human perspective we see the similarities. So that would also be, I think, a challenge we need to tackle.
But one thing more, Ilse, before we go to Maysa, when there is this requirement of full transparency on AI tools in Europe to disclose the full list of on what documents and properties, assets, everything they train their tools, how it can be feasible? Do you see that it's possible? Because there is a deadline for the new AI tools that are going to have till 2027, I believe, to disclose everything. And I always think your perspective is very interesting because pro-consumer, pro-users, but how they can ask OpenAI to disclose everything?
Yeah, so I think transparency, you would have, let's say, two perspectives. One is to be transparent to the consumer, right? Letting them know, look, this is made by AI, or we are using AI, or this image has been created with AI. That, I think, is one aspect. I think the other one is indeed more the engineering aspect, like what kind of material is used. And I think that is much more complex. And I'm also not sure in what sense it is really feasible.
Yes.
Because I think if you look at the bulk of data that is needed to train models, then I would question how much do we really know? Like we purchase a bulk of data, are we really doing a thorough due diligence, looking at all copyrighted works to see if there's any IP rights or not? It's also hard to make an estimate of the time. You would need to really do that exercise. So I expect companies to focus more on the angle towards consumers instead of the training data.
This can be so complicated because because they want to stop these big companies to scrap all the data in internet and train their models, which already happened anyway, but they want to have clarity and they put opt-out option on top on saying that, okay, if I have a novel, let's presume, and an AI tool got trained on my novel, I want to have a right to take it out, or somehow I should get compensation for the work that was used. And the big companies are saying no, because it's transformative. It's like a person going to the library and read your book. What do you want? Do you want to actually charge every person for the learning happen in their mind? This is a very big question. And then on top of that, which really interesting for me is, let's presume OpenAI, based on EU AI Act, disclosed all and every content that ChatGPT got trained on. But then what happened to the data that users are putting in the AI tool? Every day, millions of users are putting copyrighted materials like a novel, taking pictures of full pages, and I can upload it on ChatGPT. What happened to that? These are a question that nobody has the answer, right? So they are waiting to see that how the big corporates in different jurisdictions looking at it. That's why use is important, Europe and also Brazil. So what do you think, Maysa, on the training part?
Yes, what we are doing nowadays is rely on the legislation that we have. So what we do is to use copyright law, to use industrial property law, and to use contract laws, so corporate laws, to try to enforce the intellectual property usage in training. Because as you mentioned, even if we can ask ChatGPT, Microsoft, or any other company that works with AI to stop using previous intellectual property, what happens is people, millions of users are uploading information to use the tools to production, for example. So it's something that happens. And also in Brazil, fair use is not already, I don't know if in the future, accepted. So what happens is, if you're using previous intellectual property to train an AI, it's considered infringement. The problem is, how are you going to prove? How are you going to prove? So courts in Brazil are facing this kind of discussion. It's been challenging for them to understand. They are deciding case by case, depending on the proofs. But as I mentioned before, they always prefer receiving tangible proofs. So if you can prove that the output is the same as your intellectual property, it's impossible to prove that there's an infringement.
Yes.
So in many cases that we are facing in our law firm, the parts are entering into agreements to decide which I've used your intellectual property, so let's assign now a license agreement. I will pay you for the 2 past years, according to my invoices that I have issued, so that's it. So it's something that has been challenging for our courts.
Okay. As now we talked about the training part, can we also think about the ownership? So what is the role of contracts? So what is the role of contracts and terms and conditions? So we see that, for example, if the terms and conditions of an AI model are saying that any output the vendor will be the owner, how we can have contracts, and what can be the role of contracts to protect the ownership of the asset. What do you think, Ilse?
I would say that the most problem that I would say that we sometimes accept terms and conditions without reading it, because we need a service, so we don't read the terms and conditions. Yeah. So this is the most important problem.
Sometimes you don't have any option.
Just a comment,
right?
yes.
You should just say yes.
I don't even know what's going on. It's my ownership, or it's his ownership, so I'm just accepting
Yeah,
it.
so I think for using tools, this is one of the big challenges, right? Also from the consumer perspective, that we are a bit tired of the long text we see on our phone, so we think, okay, we want to use this tool, we will accept it. I do think it's very good to see that, for example, companies like OpenAI, they offer several models. So it's clear that if you have the free model, that you have less choices. If you pay a monthly fee, that you can secure confidentiality. You can opt out, for example, of the fact that your input will be used for training purposes. So there are, let's say, different layers as to the interaction. And I think from the business-to-business perspective, there's anyway more, let's say, possibility, right? Because you will negotiate from the business perspective, you can deal with all the topics you like, ownership, licenses, warranties, all these kind of risks. At least there's a possibility to arrange them in the contract. And then, of course, the challenge is always, if there is a breach, how you will tackle that, and if you want to enforce or not, because I think especially with the bigger AI tools and companies, there's also the reputation you have to take into consideration if something happens with your data, and that also depends on what kind of company you represent or work at. If you are working with personal data, it becomes even more sensitive if there's a breach or not. So I think there are possibilities, but it very much depends on the context, right?
And the level of user, as you mentioned. So there is individual and there is enterprise level. And for enterprise level, there can be contractual obligations or acceptance between the parties and ownership. But it's also important to remember ownership is different from copyrightability. And this distinguishing is very important, especially for the businesses that they are using AI models to create contents that they are consumer facing, like for advertisement, for any kind of communication with the external world. So this is also something interestingly important. Maysa, do you have something to add on the contractual?
And also, not the indemnity only, but the contract doesn't bind third parties. So they are not enforceable against their third party. So maybe we can negotiate a license in here, but I don't know if the provider using a license, intellectual property for third party. So if this third party comes, who's going to be responsible? So sometimes you need to rule this kind of situation at any time because it is enforceable against third parties.
And I see that there is something that I saw very less companies are thinking about, and that's about when there is a business and there is an AI model or a service provider who are using AI model to give services to the company, and they are thinking about, they are thinking about everything, but not the prompt and protection on the prompting part. So can prompting between the company, AI model, and service provider can be protected? Who can be the owner of the prompts? Considering that AI tools output cannot be similar always, right? Even if I own a prompt and I have copyright on top of that, first, maybe it's not unique, and sometimes the output can be different, right?
In Brazil, according to our law, copyright law, industrial property law, the owner is the contractor, except if it's established differently in the agreement. So
Interesting.
yes, how it happens. So if you contract someone to create something for you, you are the owner. Except if you establish differently in the agreement, saying that's from the provider, not from the contractor.
I think we have 5 minutes, so we can go to one more question, and if you have any questions, we can also answer. But if you want to advise one of your clients and advise them on having internal policy, which area you will ask them to focus on to have internal policy for their company, to have higher protection for copyright, ownership, any other type of IP rights? What do you think? Most important policies?
I would say the most important policies would relate to use of AI tools. So it would cover, let's say, several subcategories, but because you see, at least the company I work with, you see an enormous need and curiosity to work with AI tools. I think that would be the biggest risk. So the policy would at least cover making sure that we screen the tool before we use it, before confidential information is used in the tool. Also make sure that people know that if they work with a tool, that, for example, we can still assess whether there is any IP, either patent or copyright. And I think one aspect which is also important is what kind of source is the AI model? Are we working with open source models? Is there any obligation to return, let's say, new versions? So I would say that would be one of the major topics.
I would suggest creating contracts, playbooks, standardizations, clauses to cover identities, responsibilities, licensing contents. So I would suggest this kind of policies. Also, data protection policies to use for training. It's very important to avoid sensitive data, for example, and of course, process data only if you have a legal basis compatible with the training. And transparency and labeling, because it's ethical. It's good to say that it was created by AI, so it's something that we need to start using to create this culture among some in our companies for our clients. So these 3 principal points I would suggest.
Not only for the clients, not only for the businesses, but also for lawyers. So every lawyers I'm working with them, I really encourage to use AI, but also say, be transparent on which part of your works you used AI. And this is an advantage, this is a good thing to happen, but as soon as we are transparent about it and we know what we are doing. So this is very nice. Also, it's good to have a policy on controlling the output, right? So nothing should be used raw from an AI tool into anything, right? So we know that AI tools still need some kind of modifications. We are aware about the risk, about hallucination, data breach, confidentiality, all of those. So it's good to have a policy to increase a layer of control on the output of the AI models as well.
Maybe a takedown policy, why not?
Yeah.
But with SLAs to take it down as best as the company
Definitely,
can.
yes. Protecting the
Something like
reputation immediately. Yes, I agree with you. So I think we have, I think...
Any other question from the audience?
Yes, if anyone...
Do we have any question from the audience?
I hope that's because our conversation was very clear.
No, so we have one question.
Thank you very much for such a wonderful and different discussion. I would like to ask what kind of jurisdictional and issues you face in this kind of IP litigation, jurisdictional and enforcement issues in any IP litigations.
Jurisdiction.
I think we need this back to...
Yeah.
So first of all, I will just shortly share something. All of the case laws and precedents are still very regional or local because this is very new. So we had this conversation before the panel with another panelist who actually couldn't join. He could answer this question better. But actually, we reviewed the cases and we understood that U.S. cases are really still in, for example, Washington and New York, and we have less cross-border and less mutual jurisdictions are involved, and that's because it's very new. And also, the things happening, and Ilse can shed more light on that in Europe and also in other countries. India, for example, they are waiting to see that what happened in US because they are shifting the point of view in different jurisdictions. There are lots of vague areas that nobody knows, and still it's pending. And that's why we know that AI is moving very much faster than regulations, very much faster, and there is a gap between what is happening in reality and the litigations and the cases. You see that OpenAI is raising one in New York because they want to test to see that how much further they can go on with AI models. And this gap that we see, this only can get closed if the legal minds like you and all practitioners trying to think, ask hard questions and write more and think more about AI. Every time you advise a client writing a policy, drafting a smart contract, you are closing this gap, because waiting for the courts or cases or regulations, it will take time and it can be really late in my perspective. I hope I can share a little bit helping answering this question. But do you have anything to add?
No, I would say I agree that there's a lot of uncertainty. Also, if there are cases, it's often lower courts. So it feels like there's a lot of uncertainty, which makes it hard to assess which direction to follow. Although you do see some trends, I would say, on some aspects, as like the human fingerprint or the intellectual contribution, where you see, okay, at least globally, courts are following a little bit the same reasoning and logic. But yeah, the fact that there's a lot of uncertainty makes it a very clear indeed there's a gap between, let's say, reality and the legal, the legislation. Also because we are talking about an area of technology that is moving so rapidly. New tools and versions are created so quickly, it's almost impossible to keep track of that.
Yes, I agree. Yep.
Okay.
Saideh.
This also happens with Brazil is waiting for the decision abroad to take its decisions this mind.
Sorry, this is loud. Thank you all for coming today and expressing your various viewpoints. One of which was saying about how it's quite difficult tracking IP in regards to the opt-out mechanism from, let's say, the artist, but then, let's say, a GPT user then putting in that said item. how do you like navigate that from like an IP perspective and like litigation perspective? I know that all of this is quite new, but like that seems really difficult to chart, if you understand what I'm saying.
Yeah. So the idea was, I can explain later on. So why they went through disclosing everything out. So put yourself in the shoes of a person who spent all his or her life writing 20 books. And now all these 20 books are available in ChatGPT or Claude or any of these AI models. What they are looking for is two things. One, of course, compensation, incentives for the work that was used. And second is opt-out option. Opt-out is the beautiful idea in Europe, which we also saw in the GDPR, right? So the idea was asking these AI models to disclose everything that they use to train ChatGPT, for example, or AI model, and then the owner of the products or novel, in my example, can go and check, and if they see there is something there. And from that time, the idea is, which this is not tested in practice, they want to create some kind of a digital lock on the novel, and every time the model wants to get trained on these novels, this lock can get back to the owner, and it can go to some kind of receiving incentives, or I don't want my work to use to be trained in the AI model. So there is a future to this, which is a digital lock, putting on these assets, and on the other side, the ones that are used with full transparency to take these things with opt-out. In my perspective, I really like to look at it from the broader perspective, and that's public benefit. Let's not forget that OpenAI opened the door for all of us to learn lots of things. Of course, I agree that there should be protection. This is the idea of intellectual property area in whole, but at the same time, we should also not forget the public benefit of those. So in this area, to make it very short, there are two types of things. One is the assets that they are factual, like scientific papers, that they are based on facts. These facts can be used easier with less luck, in a very simple word. But the ones that they are very innovative probably will go through that path. So in my idea, first, public benefit is something we should not forget. The mechanism that I just explained, they are not tested in reality. It takes time to see, and I'm really looking forward to see that how these kind of things can happen. And then we should wait a little bit to see. Yeah, that was my idea. Anything you want also to add?
With you. It happens with patents. Why we protect the patents, and the patent content is published by third parties to be a source of new innovation. So what I mean is,
my partner agree, says that fair use should be used in Brazil, especially because we will benefit. Benefits will be felt by us if we can open information to this, and opt out is something that can be created to be used. So patents, what happens with patents? You file a patent application, and the state grants you a period to use that patent, but the content of the patent is published. Why? To be a source. Anyone can source and create different innovative products. So something, of course, AI is more complex than patents, but it's something that I think it's good. Should be. Yes, philosophy.
I agree. Do you have anything to add? Yes. Very good. Any more questions? I think the time is up, right?
right.
Yes. Thank you so much for joining. We really enjoyed this conversation. I hope you enjoyed as well. Thank you so much for your thoughtful attention.
Thank you.
Thank you.
Thank you.